Today is Friday, April 19th, Senate Government Operations Committee. Continuing our work on HB 875, the Ethics Commission State Code of Ethics Bill. We do not have a new draft today because we were sort of in the middle of testimony the other day, and I wanted to give Christina from the Ethics Commission and then Ted Brady from the LCT the chance to finish their testimony. And then we'll have a new draft next time. So Christina, welcome back.
Yes, Christina Siebert with the State Ethics Commission, Executive Director of the State Ethics Commission. So I have a few specific comments regarding the last draft. I think mostly just kind of to tighten up or clarify some language, and then I thought I could also go over the whistleblower protections and issues that Raleigh cities and towns raised last time. But first, I'm not sure how I'm going to start this, or should I refer to the document, or would you rather have me refer?
Whatever is easiest for you. It's on our website. Yes.
Yes.
Yeah, go for it. It's now on our website. So why don't, if you have, sure, why don't you refer to the document?
Okay. So I'm starting with, these are mostly going to be comments related to the State Code of Ethics and financial disclosure forms and not ethics. So the first change that we would suggest is, this is old language, but it's under section 117 VSA, section 2414A, which says that each candidate for state office, county office, state senator, et cetera, shall file a disclosure form prepared by the State Ethics Commission. And we would suggest changing that language to drafted by the State Ethics Commission, because I think the word prepared in the past has caused some confusion about exactly what the Ethics Commission's role is in the form. So, the candidate forms and the executive officer forms, it's the same requirements for both forms, and I think the form is assigned to us just so that it's uniform. But that's going to be the extent of it. We're not actually helping people prepare the forms other than answering some questions, right?
I see. Where is that reference again?
It is in section 117 VSA, 2414A.
111. Yeah.
Oh, okay.
Oh,
Here, there we go. Okay.
Here?
Okay.
You say draft, what you said?
Sure.
Yeah.
Draft.
And so we're moving on to 2414 AB. So this is some clarifying that I think Jay Johnson may have raised the other day regarding self-employment and what needs to be disclosed. And so we just added some clarifying language to make so that people understand that they only have to disclose clients who have business with the state department or agency, and only if such business is known to them. So our suggested language is, if self-employed, a description of the nature of the self-employment, including the names of any clients whose principal business activities are regulated by the state, or have a contract with any municipal or state office, department, or agency where such information is known to the candidate or the candidate's spouse or domestic partner, provided that the disclosed information is not confidential information, and confidential information is defined in the statute, so it's confidential under law.
Okay, that is very helpful, because this was one of the sections that Tim and I were like, how should we change this? After, so I'm glad we waited for a new draft.
Good, yeah. We would not disagree that the financial disclosure section could use some clarifying language in a few different places, so
Great,
no argument there. Okay. And so moving on, so this is regarding the actual disclosures that need to be made when it comes to publicly traded assets, we'll call it. So I think that when the discussion is happening in the House, there's a lot of debate over what exactly needs to be disclosed and when in what amounts. And I think at some point it became more general than it needed to be. So the way that it's written now, you'd have to disclose, target date retirement funds, and that's not really what we're looking for here. I don't think it's necessarily in the public interest to know that specific information. So we would suggest changing the language to make it more specific. I'll also add that the initial draft had disclosure kind of cap our disclosure amount at $10,000. Now we've raised $25,000. $10,000 is already outside, like that's kind of the highest of any state. We chose the highest. It was kind of the last minute change, $25,000. We would not object to lowering that again a bit, but it is what it is. So this is what we would suggest. We are looking at, section 117 VSA 2414 A6. We suggest that it be amended to read, starting with verse 6A, instead of publicly traded assets, individual stock holdings valued at $25,000 or more, which will be listed individually. interest in investing funds valued at $25,000 or more, which a candidate or the candidate's spouse or domestic partner exercises control over or has the ability to exercise control over, which will be listed individually. And so what we're trying to get at here is bespoke mutual funds, right? Where somebody has the ability to instruct their broker, put in 50% salary management, 50% Ben and Jerry's. We're not looking for those target date total stock index funds. I don't think that would, that's not necessary for what we're going for here when it comes to conflicts of interest. So,
Can I just clarify one thing? You made the comment about the 10,000 versus 25,000. You said 10,000 was already the highest amount of any state, so
it's a
25,
higher range, yeah.
25 would be even higher. So would you recommend going back down to 10?
That's what we would recommend. I mean, I think that the committee discussed this quite a bit, and I think the $25,000, changing that to the upper limit was maybe to satisfy some concerns that this was being overly intrusive. But we'd just like to point out that $25,000 was quite high. So we would certainly not object if it was lowered a bit.
Okay, that's good to know. We will discuss. Great. All right, carry on.
The next is newish, so interest in virtual currencies valued $25,000 or more, which shall be listed individually. So I think previously when we had discussed publicly traded assets, that would have been included there. So I'm clarifying the language to individual stock holdings. We also broke out virtual currencies. And,
Interesting. Okay.
okay. And the next change will be section F. And so this is just to kind of make a correction. I think this was inadvertently left out when there was a update to the House draft. So the details of any loan made to the candidate or the candidate's spouse that is not a commercial and reasonable loan made in ordinary course of business. So that was language that was always in there. I think it got reduced to just when the loan is made to the candidate's business instead of the individual. And so I do think that was just an inadvertent mistake. So we just wanted to find that there.
Sorry, where was that?
That is 2414 A6F.
Maybe I am looking at an old version, I don't have it. I have my list goes up to D.
Yes, this would be an addition.
Oh.
We broke it out, so
So there's an additional E as well.
Yeah.
Oh, okay.
well, yeah. The E the language was already there, but we've broken out publicly traded assets to individual stock holdings and
Gotcha.
virtual currencies.
Got you, okay.
And virtual currencies was something we were asked about in the House, and at that time it was included in publicly traded assets. So.
Great, thank you.
And moving on, and so I think Meryl Bent testified to this last time regarding whether or not to include assistant judges or probate judges in this. So I can say that we don't see any constitutional issues with this. I did send a few notes over, but we've done the analysis, and so I think TJ can actually speak a little bit more if you want some more kind of detailed information about the constitutional issues that are involved with this particular one. But the disciplinary authority, as we see it, it's not exclusive to begin with, but also, what we're talking about here isn't disciplining judges or making requests of judges because they're judges. It's in their role as a state public servant. And those are two different things. And you can look at state statutes to see, continuously there's dozens and dozens of examples when it comes to legislature passing legislation that applies to judicial officers that is then enforced by the executive branch. So we have the state bribery statute that, prohibits bribes, and it specifically includes judicial officers that's passed by the legislature, enforced by the Secretary of State. So many other examples that we could give, even just down to, taxes. Judicial officers pay taxes like everyone else. The executive branch enforces tax penalties on people. So this is really not a situation that would raise constitutional issues, and happy to have like a more detailed or discussion about that, but maybe actually I'll throw it to TJ because I think he can talk about, regulating or judges in their role as a judge versus their role as a state employee, if that would be something you think would be useful.
Yeah, I think that would be helpful. TJ, if you could just introduce yourself for the record, I think you haven't yet testified, so just so we know who you are and what your affiliation is, that would be great.
Sure, thank you. I'm TJ Jones. I'm currently a professor at the University of Connecticut in the Public Policy Department, and I've been able to help the commission over the last couple of years in trying to navigate toward a code that is good and fitting for the state of Vermont. My former life, I was the first ethics prosecutor in Connecticut and executive director for the Fair Political Practices Commission in California. So I've been through a number of jurisdictions that have it's sort of traveled this route in creating new codes or amending their old codes. The issue of judges has come up in my experience on several occasions, and it's always brought up in the constitutional context. It ends up for most states. Many states cover judges in their actual code of ethics without much distinction at all. But the key distinction for constitutional purposes in most states, and I believe in Vermont, is that the ethics code doesn't touch judges when they are engaging in a judicial function. And that's the key constitutional component. When judges are judging on the bench, the ethics code from the commission doesn't apply. Their judicial code of conduct does. But off the bench, say if you're in a position where you want to, and I'm making this up, obviously, hire your son as a clerk, as opposed to more qualified people, that would not be within the judicial function. That would be no different than any other state employee. And you may remember, at least Senator Clarkson may remember this from years ago, we came up with the same issue with regard to legislators in terms of making clear that the code of ethics does not apply to legislators when they're in their legislative function, and it's not intended to. And in fact, in that context, we put in additional language into that provision, making clear that none of this has anything to do with legislators executing their legislative function. This current bill doesn't have that in that, but if that gave more comfort to the judiciary, that would not change any of the provisions in here, and maybe they may be amenable to that.
That would be helpful if you could suggest some language that we could run by them.
I think they need that.
Because I think at this point, they're very uncomfortable with what's in the bill. So if you have suggested language that we might be able to use and see what they think, that it could help. And also to see what our attorney thinks.
I will do that. And I will hew it close to, just to telegraph where this will go, I will hew it close to that language that we inserted on behalf of the legislature the last time around.
Oh,
That would be great. Thank you, TJ.
TJ,
Sure.
good. Thank you.
Thank you.
Yeah, and I did say there was also an issue raised about sharing aggregate data. I don't think that goes beyond anything that's already shared on the Judicial Conduct Board's website. So they do detail complaints that were filed under the Judicial Code of Ethics there. And I will note that they tend to relate to probate judges and assistant judges when it comes to complaints. So, and that's specifically who would be covered under financial disclosure. So we do feel like that is a good add-on here in true setting.
Right. Say that one more time, Christine.
So in terms of that, I think there's an objection to sharing aggregate data in case there are confidentiality issues, but they already share complaint data on their website that's publicly available. So I don't think we're asking for anything that isn't already shared there. And also we've noticed that the complaints pretty much almost exclusively relate to probate judges and assistant judges. And so that's what exactly the financial disclosure requirements cover.
Right.
And so moving on, section 9, 3 VSA. 1223C. And so this was a consultation requirement that was put into the bill. So when we refer complaints on over to other agencies, this allows and requires actually some consultation regarding the issues that are covered by the complaints. And so part of the reason for this is just to develop a common understanding of the code of ethics so that everyone is working on the same page. We would ask that there be included a requirement that it be in writing. And this is just so that, you know, as we're moving forward to this, with the code of ethics, everyone developing a common understanding, everybody being on the same page, the code of ethics being applied uniformly. We just want to have our advice or opinion in writing so that there isn't room for misinterpretation, so that it's documented, so that it can be shared easily amongst everyone. I mean, we will put our opinion in writing, but we do think it's important to make clear that the Constitution is writing.
Okay.
And next, so we're moving on to the Investigatory Powers Ethics Commission. So this is section 12, the VSA 1229 F2A. And so there's one change that we would suggest here. So there is provision that allows for resolution agreements. So when a complaint is filed with us, at any point in the process, we can enter into a resolution agreement with the respondent. We've noticed a lot of cases where complaints are filed with us and it relate to really kind of they technically violate the code of ethics, but also, very low level violations. We want to make sure that we can really use the opportunity to educate, and that's available to us. And so right now, if we enter into a resolution agreement at that very early stage, and the resolution agreement at that stage is really going to be, okay, this is a violation of code of ethics, maybe it's something you've been thinking about or realized. The resolution here would be to, agree not to do it again, but also to take 30 minutes of training. So would you like for this to be the result? We can enter into that agreement versus forward it on for potential investigation, either with the Ethics Commission or somewhere else. And so we do think that that's an option that a lot of people would like for that to be able to remain confidential. So we'd like to put a summary on the website because there's a public interest in people knowing what kinds of complaints are involved in resolution agreements, but we wouldn't have to reveal the identity of anyone. So we would like to add that option for them. Okay, subpoenas and oaths, and I think this is also an issue raised by Jay Johnson. So I think she recommended language that would require us to seek documents on a voluntary basis.
Where are you now?
Oh, sorry, so section 13, 3 VSA 1230D.
So D timeline for determination.
Page 20.
All right, that's what I needed, okay.
So we saw that, Jay
All right.
Johnson, okay. There's a suggestion that we require to seek documents or information voluntarily before resorting to the subpoena process. This is something I think, again, that TJ could weigh in on. But subpoenas are really used as a last resort. And there's something that you wouldn't reach to as, they're time consuming, they're expensive. And so that's always going to be the case where you're seeking documents voluntarily. But in those extreme cases where a document may, intentionally be made to go missing, you do want to have the option to seek it by subpoena first without, necessarily creating a situation where the information you're seeking is no longer available. So we have suggested some language in here that would, I guess, the language would be, except in cases where the commissioner or staff reasonably believes that materials will not be timely produced, the commissioner or staff shall seek voluntary compliance prior to the issuance of the subpoena. So it is putting in writing that will seek voluntary compliance, except for those extreme cases where it would not be the wise thing to do. And I think TJ has noted that the voluntary compliance, seeking voluntary compliance would be new in Vermont law. So we haven't seen another place where another organization is required to first seek voluntary compliance. So
Well, actually, we asked for a lot of that in the DMV. I mean, our seatbelt laws, basically.
okay. All right.
I mean, we do ask it elsewhere.
Okay. All right. So the makeup of the Ethics Commission, and I think this is the most important thing we're flagging here.
Wait, before you go on, sorry, Christina, I do want to ask TJ about if you could give me a couple examples of what made using a subpoena where requesting wouldn't be in the best interest.
Okay. I'll let TJ answer that because he actually has experience of prosecuting ethics cases. So
Okay.
Sure. Where production is available from voluntary compliance, that is always preferable, not just for the recipient of the document request, but for the commission itself. Subpoenas are invariably a hassle because if you're in that sort of confrontational relationship with somebody that you want documents from, you're in a situation where you may have to litigate a subpoena. You also have to draft it up. You have to make sure that it's not going to be quashed by a judge, and prepared to fight it up through the court system. So it's never in the commission's interest to issue a subpoena when documents can be available readily. So the subpoena is used really in a couple of circumstances. The first is when voluntary compliance fails. And the second is when you are worried that if compulsory process isn't issued, then some information will go missing. And it's that situation that is a particular concern here because of the tight timeline that's currently in the bill with respect to investigations. Voluntary compliance often will take, iterative negotiations. But that gets gummed up a lot if you ask a witness or somebody who's the subject of a complaint for documents, and there is a fear that they are going to misplace some of the critical documents. And in that situation, whether it's just a voluntary request, the commission has no remedy. So it's those rare occasions where you have concerns based on the existing facts that documents or even witnesses are going to disappear. I've previously had witnesses be asked for voluntary compliance and they leave the state for a long vacation, which they can't do if they get served a subpoena within the state.
Right.
Now, there are other safeguards that other states have put in place. If the concern is that the commission will, for whatever reason, start issuing more subpoenas than are necessary. And again, I've never seen that, but if that's the concern, by way of example, Rhode Island will, the commission itself has to issue the subpoena by a majority vote, but first the executive director or the investigator has to submit an affidavit to the commission testifying that these documents are necessary before the subpoena can issue. In the state of Connecticut, it is majority vote of the commission before something can issue, except in emergency circumstances, and then the chair can sign off and then report back to the commission at the next meeting. So there's a variety of safeguards that you can put in place if the fear is that the commission will be overly aggressive in issuing subpoenas. And again, I haven't seen that, but I respect that is a valid concern.
Okay, and I'm just looking at the bill, thank you, that's helpful, I'm just looking at the bill to see does it require a vote of the commission before they issue a subpoena? It doesn't look like it.
No, I don't think so. At least part of that in line.
Okay. All right, this is good to think about, carry on.
So the makeup of the commission, so we would like to offer an alternative, and this is something we raised with the House, but it's at the very end of the session, so didn't actually reach the level of testimony at that point. We'd like to suggest the membership of the commission. So right now, the makeup of the Ethics Commission is quite unique compared to other states. So we're mostly
Sorry, we're moving to.
So we're moving to section 15, 3 VSA 1221B.
Okay, right.
So right now, makeup of our commission is we're almost exclusively have commissioners appointed by nonprofit organizations, professional organizations, which is fantastic when it comes to independence. It is unusual because generally speaking, ethics commissions are made up of those who are appointed by government officials, and that is for constitutional reasons. Right now, we are an advisory commission, so we don't see a constitutional issue now. We do not see a constitutional issue with anything that is in this bill, and I do believe that Legislative Council looked into this. We first flagged this with the House when we were discussing it for the Parish Commission, and so all parties have looked into it. We don't see any issues with anything in this bill. However, as the Ethics Commission is moving forward and we get, looking to future years when we get more authority, more power, we do believe that the commission, that this issue is going to come up again. And so when we're looking at the makeup of the commission, we wanted to take the opportunity to course correct now. I mean, this is when we're discussing this issue.
Right.
And course correcting would be to basically make sure that these constitutional issues that are, kind of amorphous and don't really apply now, don't become real issues in the future. And to do that, we have to have commission members that are appointed by government officials. Right now, we have one commissioner who is appointed by the Chief Justice, which in itself is very unusual. I think TJ can testify that we may be one of the only states that has that, but we do not have anybody appointed by the legislature, and we do not have anybody appointed by the governor. And those are two things that we think we need going forward, in addition to needing an odd member of commissioners. And so when some of the municipal officials were testifying with the House, they said that they felt like municipal representation needed to be more than what it was. So our suggestion is to have one member appointed by the legislature, who shall be a former municipal official. That's quite important. So right now, we don't have any member who is, currently.
Kill two birds with one stone.
Yes. We don't have anyone who is covered by the State Code of Ethics in a context other than the fact that they're a member of the Ethics Commission. And also one member appointed by the governor, who shall be a former municipal official. Municipal officer, and so that will give municipalities double the representation on the commission, something that was noted, and also resolve the issue of 6 versus 7 and looming constitutional issues, we'll call it.
Is the constitutional issue such that at least some members need to be appointed by government officials, or all the members?
So that is a question that TJ may be able to weigh in more. We think that we are safe as long as we have some. In the future, if it becomes an issue, then we do think that there's a way to kind of convert it more easily to recommendations. But right now, we do think some is enough.
Okay, Senator Clarkson.
So I would love to not restrict the legislator who serves to being a formal municipal official. We have many legislators who are current chairs of select board or serve on select boards or on school boards. So I would hope we wouldn't make it just a former.
This is not supposed to be
Oh,
elected.
currently, that's right, they
Appointed
can.
by a legislator, by the legislature.
Yeah, it's not a legislator. It is appointed by the legislature.
A person, okay, I'm sorry.
Yeah. We will have to
Understood.
tweak this because the appointments are usually the speaker
The speaker,
or
yeah,
the committee on
pro tem.
committees or the pro tem. So I'll ask, we're trying to stay with 7 members, it might be challenging, but we can try to work that out,
Okay.
if we decide to do this. Did you have a question, Senator Bielanski? Okay.
And I'll say, because I know budgets come up, we can absorb new commissioners. It only costs us about $1,000 a year.
Okay,
We can absorb that into our existing budget.
okay.
Yeah, and part of this is, making sure it's very paramount that the Ethics Commission maintain its independence and impartiality. And I think that we have that now. Like, we don't have, the organizations that appoint people now, there's really no question, the accountants organization or, SHRM, they're not politicizing the process anyway. There can be really, accusations there. They're really there for their knowledge only. And so we've had a lot of success, I think, maintaining our independence. And so it's really important to us that we maintain that. And, I do understand, I was the person who suggested Vermont League of Cities and Towns initially. And so I recognize that was my, how do I put this? I don't think we realized at the time that Vermont League of Cities and Towns wear so many different hats. And one of them is a membership organization, but also an advocacy organization and also an insurer. And so the insurance part is where it really became clear to us the financial interest in the work of the Ethics Commission and the incompatibility of that. So, I do apologize for that. And we're hoping that the fact that we're suggesting 2 former municipal officers, and that would be, or at least 2 municipal officers, that's going to really represent municipal interests there. Because we do have 2 former state employees on our commission. That is not by design, that just happens to be that way. But it is really good to have people who are, familiar with the systems that we're talking about and familiar with the issues that come up. So, yes. That would be it for the comments that we have in writing that have been submitted. I think that TJ, if there's any questions about the constitutionality issues when it comes to ethics commissions, he's always available either now or by email later. if you like, I can move on to the question of whistleblower protections for members of the public. Is that something you'd like me to do now?
Yeah, are there questions on this part? Christina? Okay. Hurry on that.
Okay.
Sure, so I guess I just have one question before we get too much further. Have you and Jay spoken about that section that Jay had concerned about the subpoenas and those?
I did not speak to her directly. I could do so. If you want, I could reach out to her if you'd like.
Curious if that satisfied her.
Okay.
Well, I think, yeah, I mean, I will
We
work
can do
with
that.
Tim we'll have another draft and we can send it to Jay to look at, to see if seems like it was okay for her. Go ahead.
Okay, so the state whistleblower protections or the whistleblower protections for members of the public. So that is something that came directly.
We're now on page, sorry, I just didn't want to keep up with you because you move at lightning speed.
No.
That is on page 48.
Okay, thank you.
Yeah, I apologize, I'm working from my notes, so.
Right, so.
Yeah, so
it
I'm
all
not,
must need to be-
I set myself up to be, not in alignment with these, so I apologize for that. Yeah, so I think the initial question was, the current state whistleblower statute only covers state employees. And so the reason for that, that's because it's part of State Employees Labor Relations Act. So just to get that portion out of the way, it's they're in the employment context already. But this really came about from the listening sessions and also from what we hear from people who call us members of the public and their concerns about retaliation. So I'll say that this really comes up in the municipal context. It does not really come up in the state context. Occasionally when we're asked for advice, then state employees will mention it, but we have, I think, maybe once we had a member of the public mention it in the context of something that had been an issue that's ongoing for years, but we really never hear about it from members of the public when it comes to state ethics. We do hear about it in municipal ethics. And so in recognition that we do not actually we're not offering an independent way to file complaints in this particular draft, we wanted to make sure that we did something that was protective of members of the public who are concerned when they raise complaints. And so even though this is still quite narrow, we felt like this is the one thing that we could do. And I can address some specific issues that were raised. I think there was some concern about the specific language. There's a broad definition of retaliate that includes interfering with any right or privilege. And I can just give our take on this in terms of the terminology here. We view this as, a legal term of art. So we're talking about a right, that's something, the Constitution grants you rights. When you're born with inherent rights. We're talking about privileges, those are something that is granted. So that can be a license, that can be a permit, you apply for a contract. And so there's a specific terminology, legal terminology that goes with the term privilege, just to mean like, anything. There's actually a legal definition here, and it's exactly the type of thing that people are worried about when they're worried about retaliation. You're gonna file a complaint, you're gonna leave the jet. You have a permit pending, you file an ethics complaint, your permit is denied. And so this is really to get at the specific act of retaliation. You're denying the permit not because you have legitimate reason to, but because you're retaliating. And then that person is going to have to actually prove the connection in court. So it isn't just something where they raise the complaints and then they say, okay, that's it. It's you're going to have to hire a lawyer and you're going to have to show that this was an arbitrary decision that can be traced back to the ethics complaints that this person filed.
Okay, hold on one second, Senator Wiggins.
Thank you, Madam Chair. I'm just trying to follow along here. So we had, and I think I heard you say that this language is exactly the same as what state employees have?
No, it's
Or
different.
yeah, you're saying it's different. And it appears to be a higher standard.
Well, I think it's different. So when you're looking at the state whistleblower statute, and there's also the False Claims Act. So I think some of the things are in line with the False Claims Act, but when we're looking at the state whistleblower statute.
And the false claim, just so I understand, the False Claims Act covers state employees only? Or it also covers who's covered? I'm not familiar with this piece of legislation.
I think it's also in the employment context. So for me, the biggest difference that we're proposing here is we're taking whistleblower protections outside of the employment context and offering it to members of the public when it comes to municipalities. And so the definitions in the False Claims Act and in the state whistleblower statute are related to retaliation in the employment context. And so what we're seeking to do here, the difference is that we would also offer it to members of the public and it's interfering with any right or privilege. Privilege would include contracts, permits, licenses, things like that. So that's the difference there. Some things that we have in here align more with the False Claims Act, and that would be, for example, the the limit on when for an action. So we have the window of 180 days. We're talking about the state whistleblower statute. The False Claims Act creates a window of 3 years. And so 3 years is what we put in here. The reason we've chosen the longer period of time where you can file a claim is number one, because in the employment context, you're more likely to realize that you've been retaliated against, right? You demoted, you get a performance review. When you're a member of the public, you don't have that same, kind of access. It might not necessarily be as immediate, but also we do think that 180 days is quite short. So if you look at, across the nation, if you look at the Federal False Claims Act, they go from, very short periods of time for a couple months up to several years. And so we think 3 years is actually in line with the False Claims Act, so it's not totally new for Vermont. It's actually more restrictive because I think they have 3 years from the time you knew kind of the action and you knew the action. So potentially that reads as longer than 3 years, whereas ours puts 3 years at the upper limit.
Okay, so just so I understand, have you seen the comparison between what state employees are required to do and what we're doing in this bill as it stands?
I've seen the one that the Vermont thinks is
Yeah,
fantastic.
that's-
That's where my notes are.
Okay, great. That is concerning to me, that we have a different set of standards for these two groups, especially when municipalities are in a situation where we've said it time and time and again, they're less staffed, they have less resources, they are more susceptible potentially being targeted in some ways by, I think, false claims. I'm confused by some of the logic you're using that you would recognize retaliation sooner as an employee versus a member of the public. I think 3 years is too long a period of time, especially if you've ever dealt with a grievance from someone who, having up to 3 years to, yeah, I'm a little concerned by that. I think 180 days seems to be sufficient at the state level, so you're saying that because you would experience retaliation much quicker because you'd be fired. But when you experience retaliation, like the form of retaliation, why would someone wait longer for a person in the public? Like,
I think it's the knowledge of, so say you have a permitting process that's taking a very long time, say that, a decision was made against you, you don't realize it and then later you find out that the person who filed the complaint against was advocating against you, and then you make that connection later. But I'll just say
like a permit, you're saying like you would wait like years to get, I'm just trying to have an example because I don't understand.
So, yeah, so for example, say you have a contract with a municipality and it's a 2-year long contract and you're, 9 months into it, and then 2 years are up, the contract isn't renewed. And so you don't see an objective basis for this. And then you investigate it and you find maybe it's open meeting law, public records law, some other way that you discover that the reason you didn't get the contract is because of this ethics complaint you filed. So just talking about the difference between state government and municipal government, I think Vermont League of Cities and Towns raised this in their presentation. So within state government, there's a hierarchy, right? Within municipal government, it's flat. So we're looking at state government. There's actually a way right now for members of the public to get redress if they feel like they've been retaliated against. So it's not specific, but they can complain to somebody's supervisor. They can file a complaint with the ethics commission. They can file a complaint directly with, DHR. There are multiple ways that somebody can say, I have been retaliated against. Here's my proof. And then they can get redress, and then it can be looked at as employee misconduct. But as Vermont League of Cities and Towns pointed out, municipal government is flat. So there's not really that level of oversight that's happening there. In many cases, there can be nobody that you can actually go to for redress. If you have a complaint against the town clerk, who's going to oversee that complaint? How are you going to discover it? There's fewer
You're an
opportunities.
elected official in many towns.
Right, but that's what I'm saying is that, you have a lot of people there where there's just no opportunity for redress, especially because we don't have a complaint process in place. And what that is different from state government, where there are many opportunities for redress. It may not always be satisfactory to people, and we're trying to improve those opportunities, but that is one of the differences. While we think that whistleblower protection should be extended to members of the public, where they aren't specifically mentioned in state statute when it comes to state government.
And members of the public is anybody, not just, because your example is I've been financially impacted, so I'm not just a member of the public, I'm in a contractual agreement with the municipality. That seems like a different thing than me as a person in public saying, I think that there is an ethics complaint against this person or staff member because they did something I don't like. So that's different. So I'm trying to understand why that person needs so much protection if they're not in a situation where there's a contractual agreement or like a financial implication. I have difficulty with this section and I'm trying to come around.
I hear that. I think we'll hear more testimony on this. I'm assuming Ted will talk about this, and we'll also gonna ask our legislative council attorney to explain the various
Okay.
sort of, this is what state employees have, this is what the False Claims Act is, this is what this would do, so that you can get a sense.
And I think the
of-
employee versus public is a really important distinction.
Senator Bihowski.
Yeah, well, so as I'm thinking of a member of the public, one thing I'm certainly thinking of, and this is drawn slightly on something I know has happened in one of the towns I represent, and that is, someone has made a complaint and 7 months later applies for a permit to build something in their yard and it is declined, and it is declined at what is later found out because the person they made the complaint against advocated really hard that they not get that permit. And this is why I think it's the lengthier period of time for me, in my employment setting, I come in contact with my supervisor every single day. In the setting where I'm engaging with the board, potentially I don't come in contact with them every single day, so it may take a longer period of time for that to occur. As opposed to like, I made a complaint against my supervisor and the next week he fired me.
So your point is that, but wouldn't the whistleblower protections go from the point of making the ethics complaint and moving forward? So why would that not cover that situation?
Well, if it only is 180 days, that situation happens 7 months later, it's outside of 180 days.
But isn't the example of them acting unethically by denying the permit that as well? Like, wouldn't that also be, that would also be an unethical form of like that's under that. Right?
Well, I think that there's some other unethical behavior that has, or potentially unethical behavior that somebody's filed a complaint about.
Yes, and then something impacts them later, which is also unethical behavior, so why would that not be also why would they not be protected?
They would have to file another complaint about that denial of permit,
Yeah.
saying this is unethical again. And I think the whistleblower protection is basically protecting somebody who files a complaint from having retribution. So that trying to prevent the denial of a permit or something like that because you filed a complaint. It's more preventative than reactionary in a way.
So let me just understand this, so in this scenario, after the 180 days, if you got your permit denied, you wouldn't be able to file an ethics complaint on that because of your original complaint, you had lapsed in time?
No, you could continue to file a complaint, but TJ, I'm gonna turn to you to see if you can provide any explanation that might help clarify the situation for Senator White.
Sure, I think I understand the question. This provision, and I'll admit up front, this is not standard for most ethics codes. It is standard for a variety of other types of statutes where citizens can file a suit if they're harassed or in response to a complaint that they have filed. But essentially this has less to do with the commission. It just creates a private right of action for citizens who can show that they've had usually a financial loss or a loss of some privilege that they used to have. So a paradigmatic example would be, say you've gotten a permit to put in a new driveway, and you hire a company, and the company starts putting in the driveway, and something else happens in your other life where you're forced to file a ethics complaint. Well, 24 hours later, your permit for your driveway is pulled. You've already incurred costs with that, so you can show a financial loss. You can show the deprivation of privilege. And what happens then is a cause of action is created. The individual can file a suit. It's entirely up to the individual to show all the things that the complaint was filed, the retaliatory action took place, that there was damages that took place, that the retaliation was related to the complaint. So there's an evidentiary threshold for the citizen to have to prove in the court. And again, the commission wouldn't be involved in this. This is strictly based on really voluminous amounts of people who raised this in the listening sessions. So much so that I was a little surprised that it was echoed from person to person. This idea that they were powerless to do anything, but they had been retaliated against.
So can I just ask one follow-up?
One more. Yeah.
Okay, I would like to understand this, so maybe I need to do some offline time because I'm not comfortable with this section of the bill yet, but my understanding is now, if I'm upset about that and I filed an ethics complaint and I feel that there was retaliation, I can't sue the planning commission or the planning commissioner on this issue, but this would allow me to do that.
You can.
Yes, if they retaliate against you.
Sue the planning commission member as an example. I can't sue a state employee now.
Yeah, I think that TJ maybe talk about qualified immunity. And so when you're suing that individual, it's going to be a lawsuit where they're acting outside of their official duties. And so then there is personal liability for that. But, just to be clear, this is a case where retaliation has actually happened. And we do have cases, I can use some real life examples. We had somebody who was in a dispute with their neighbor who was a town official. The town official was threatening them using their government account. He needed actual documents from the municipality to prove his case in court. This person denied them, just flat out denied them. So this person went to the city attorney, they went to the select board and said, "Can you help me with this issue?" And they said, "Yes, of course." And then he told them who the dispute was with, and they said, "No, we can do nothing." And so it just left that person in a place where they were being retaliated against for this private lawsuit over what is essentially a neighbor dispute. And so, sure, you can challenge this under open meeting law, but the underlying behavior of retaliation is not what's being addressed there. And we very recently had someone was very concerned because they were in a dispute with somebody in their town. And then that person and their relatives ran for the select board, got select board seats, and they felt like the intention of this person was only to do that because they wanted to use their position of power to retaliate against this person, and they had not adopted the conflict of interest policy, and so there was nothing there to enforce the recusal. And so we're looking at situations where nothing has happened there yet, as far as I know, but there is that concern there that somebody's going to use that position specifically to retaliate against people they have personal disputes with, and what is the recourse there, because we don't have an independent complaint mechanism yet.
Okay, we're gonna move on to Senator Norris. You had a question.
Yeah, thank you. It goes along with Senator White's. Obviously, we live in a very litigious society here. I can't see any language in this bill that would prevent or preclude anybody from bringing civil action against anybody for whatever reason, because it's done on a daily basis. I've experienced it. It happens all the time. So without this language, you're saying that it couldn't happen.
One thing, it depends, those are very fact specific situations, so I think here what we're really trying to get at is actually narrowing it down, right? So if you're bringing a claim for retaliation, then you have to actually prove the retaliation. Right. And so that I would see this as actually more protective for people when it's not just, we're having these general disputes. You actually have to prove that you have to file a written complaint somewhere first. And it can't just be something like, "I think I've been retaliated, I'm going to sue you." You have to file a written complaint. You're going to have to, hire an attorney unless you're going to take it on yourself. And then you're going to have to, go to court and prove that. And so it's a specific, avenue that protects people who are filing ethics complaints where it's just not there now. And like I said, like TJ said, we recognize that we are going beyond what's currently in law, but the reason for this is because we hear about it so much, and we just want to be able to offer something to people. Because it's still, I really view this to be something that's going to be used in the most egregious cases.
Okay. Well, we're obviously gonna continue the conversation on this. I think we should move on so Christina can finish, because we still want to hear from our other witnesses, so. Go ahead.
That's it for me, so I didn't have any other questions, but those were the main points I wanted to cover.
Okay, Senator Cox.
Can I just add, because something that Senator White said just concerned me, which is, I don't care what size town you have. Everyone should be abiding by the code of ethics. So to me, the size of the town doesn't matter. I think all of us who are public servants should be abiding by the same code of ethics. So, yes, some towns that are under-resourced doesn't mean they shouldn't be abiding by, shouldn't be employing ethical behavior and everything. So, I think the plus of the Ethics Commission as an independent commission is that it liberates the LCT from having to deal with these. And it really creates a direct avenue to deal with some of these behaviors, which have in many ways gone without any recourse for people for a long time, and you heard that and you're listening to her. And municipal challenge, I mean, it's where we observe it the most acutely, it's where we observe it clearly, I mean. A lot of our constituents are gonna see it with us up here necessarily, but they'll see it with people closer. Which is, I think, why it's so closely observed. So we wanna protect our municipal public servants as well as we wanna protect our public, and I think that's the balancing act.
And I should make clear, when we're talking about, privilege, we really are talking about, there's gonna be almost certainly an economic loss involved in that with this definition that's here. And it doesn't cover things like, general harassment or vandalism or things that we've heard about from other people. I mean, that will still leave, it's very general behavior out of it. It's really when there's a specific retaliation related to something like permit contract.
Could
Okay,
Can I ask one other question?
we have two more witnesses and we're behind, so.
Okay, if a municipality has a situation where so I'm on a select board, the way that this whistle.
Senator, I think you're gonna have to wait. I said we're out of time, so Christina, thank you.
Wait around.
Ted, come on up, please.
Thanks.
See you, thank you for coming back. Did you submit revised or updated testimony?
I have
or-
not.
You have not, okay. So you didn't get a chance on, when was it, Wednesday? Wednesday to finish, to testify, so I just wanna give you a chance after you heard from the Secretary of State's office. So,
Thanks.
yeah,
I'll be really quick and then just do questions. So Ted
Sure.
Brady from the Vermont League of Cities and Towns. Ultimately, the conversation we're having with the Secretary of State's office and the Ethics Commission was to try to find some spots that we agreed on. I think from the league's perspective, we're pretty uncomfortable with the idea of implementing a statewide code of ethics. It's not the way we prefer to do it, but as I've said before, we're game for supporting that idea here in the Senate side and supporting the Ethics Commission, and supporting the House position on that. That's a big give for us. I just want to be clear. It's not like focusing local control. The other big give is we've heard the arguments that towns really want an access to legal opinion about ethical behavior. We do that now. I think it's been dismissed that we do that. Said that we multiple times have heard that we can't provide adequate response to a municipal official. We can. We do 80 times a year. But we have absolutely no issue in thankfully giving towns more access to more legal minds and through the Ethics Commission, which is in this bill. Again, we're a little uncomfortable there, but we support it. We'll support that position here. And that's kind of what we're saying, trying to come to the table and say, we hear you, we're trying to be a cooperative partner. The training requirement. We do not think the idea of requiring a municipal official to get training, and this is not the place we'd start. There's a lot of stuff. However, I think when we came to the Secretary of State's office, to the Ethics Commission, and said, if you can narrow the definition of who needs to be trained, I think we can get over that and accept the first training requirement in the history of Vermont for municipal officials, depending if S55 passes. Yeah. But that S55 is a good example.
and
You
it
really
depends on
have-
what you're saying, it's a municipal official, because with the School Boards Association in the room, there are municipalities and there are requirements for their training, so.
I do not, fortunately, know about that.
That's what we base the training requirement in S55 on.
Anyway, go ahead.
So narrowing it would be really appreciated, and that's I think what we're trying to come to you with some language. From there, our position we haven't been able to come to a comfortable place, but we really support an idea of either leaving it to the towns right now in the existing language, the existing sections of policy.
About the train.
Moving on from training to reporting and investigations. The current conflict of interest policy requirements and ordinance authorities that are in statute about conflict of interest, that seems like a good place to tuck in reporting and investigations right now. And we fully support, having a conversation with the Ethics Commission and with Secretary of State's office and other partners in trying to find ways to bring you a better proposal that we think works for municipalities on reporting investigations and, reporting investigations primarily.
And that was part of the sort of, nascent compromise that's happening was, and were you comfortable with where you landed, or was there still more work that needed to be done?
We were comfortable with
Okay.
tucking it into the existing statutes, giving municipalities the authority to do that,
Uh-huh,
and then studying how we could get beyond that.
okay,
That was
okay,
our,
that's where the three of you landed.
I don't know if we all
No.
landed there. The first part definitely, the second part, I'm not 100% sure.
Okay, okay,
The first part being tucking the investigatory and reporting requirements into the existing code authorizing municipalities to have conflict of interest policies, and the existing code authorizing municipalities to have ordinances surrounding this. Ordinance authority.
okay,
The second part being, how do you do investigations? How do you do reporting?
right.
I don't think
That's
there's
in the
agreement.
future.
And I don't think there's agreement as
Okay.
to the fact that it should be in the future.
Oh, I see, okay,
Oh, I
Like,
thought this was a place to start, that you were coming in with.
I feel that way. I think Warren represented that the Secretary of State's office would be okay with that, but I don't believe the Ethics Commission was there.
I think my understanding was that we removed the requirement that the investigations requirement, because that is something that we heard in some municipalities who aren't already doing it. With the understanding that we would put a timeline into this bill to have a proposal next year or the year after to actually set up an independent authority to hear complaints, and that would be the trade-off there. Status quo for now, but with the idea that we're actually putting something in writing with a timeline to set up something that's different.
okay, and that was the difference, okay, okay.
Which is, I don't object to what she just.
Oh, okay.
Oh,
Well, so then it sounds like you're,
It might be closer to,
Yes.
closer than I thought.
nice, I love it.
But the final area that we really don't think we're gonna be able to get anywhere on is on the whistleblower side, unless you restricted that to municipal employees and matched the code with the state. We don't think giving private citizens the right to sue for retaliatory action against a municipal official or municipality, and you don't give that same right to the state. Private citizens can't sue the state for those things under the same using the same concept, and we struggle with that greatly.
So for an example, back to the permitting question, if the state denies a permit, it's a sort of, you can appeal that denial, and there's lots of things, and then eventually, depending on what kind of permit it is, it could be appealed to some court, the environmental court or whatever. So if a citizen is denied a permit at the local level, building permit or whatever, is there already in existence a way for them to appeal that and then eventually take that appeal to court?
Yes, so any DRB decision is appealable to the environmental court. The example that was used of somebody being denied access to records, that's a violation of the Public Records Act. That's something you could get a lawyer and go get that cured. You'd have to get a lawyer to get it cured this way as well, except you're now going to open up to compensatory damages, punitive damages, legal fees, all these things.
Mhm.
So yes, you'll probably find an example where there's some retaliatory action that some municipal official can take that would not have some hierarchy that you could go like to. I can't think of it right now. I'm sure there's some place
Mhm.
for them. But most retaliatory actions, you would have a place that you could actually appeal with a lawyer to get the proper outcome.
So this is obviously something we'll continue to follow. Did you have a question else?
Yeah. I guess it's the state just doesn't feel, well, it does. There are so many examples, of course, how the state interacts with its people. But, we deal with our municipal officials in a much more intimate fashion. I mean, if your road isn't plowed and it has economic and life threatening, it's got impact on your life, in a different way than if you don't get a permit. Now, I would also say that, AHS has very direct personal impacts on health and welfare as well. But I think that the reason I think that this is important to keep is just we experience it on a much more personal, aimed at you personally, not you because the idea isn't good or because of the permit, you know what, that it's a much more personal experience in a municipality. And I think that's why I err on the side of supporting the ethics commission on this. And I don't think if there aren't problems, I don't think any town should be worried. I mean, I think frivolous things, we have ways to deal with frivolous things. I think the ethics commission would see that. I mean, so I don't think people were working thoughtfully in an equitable fashion and anything to worry about.
I think if it's good for the goose, it's good for the gander. And why don't we do this for the state? Because there are a lot of, as you said, very personal interactions, opportunities for retaliation. I think with the school board association, there
Yeah,
are
I
a
agree.
lot of opportunities in the school system. There's every time the government is involved in your life, there's opportunity for
No, I don't.
bad.
Yeah.
Fortunately, there's a lot of good outcomes.
A pretty damn good outcome a lot of the time too.
Yeah.
I'm sorry.
You're right.
In every natural disaster, they turn to us.
Senator Norris.
Yes, thank you. I have a lot of confidence in the league. Okay, I think they do a great job from insurance to ordinance to helping these towns and so on and so forth. It's nice that you're willing to say, well, we'll compromise on this, this, and this, but I do agree with that if the state doesn't do it, I don't know why municipalities should be required to do it in this particular bill. The municipal ethics portion of this bill. Does the league support that?
Establishing a uniform code of ethics. Yes, I think we're getting to the point where we would support inclusion of that in this bill.
You don't have that already within the league's policies?
We do, we have a model conflict of interest and ethics policy that covers a lot of what's in here. And so that's kind of why we say, okay, we think it should be a local decision. And we think municipalities should be able to adopt this thing and customize it to themselves, hold themselves accountable to it. At every organizational meeting they have each year, pass a policy that says, we're gonna hold ourselves to this conflict of interest policy and this ethics policy. I think that's the best way to do it. However, what you have before you in the Uniform Code of Ethics is largely what we suggest they implement. And there are some things in there that we didn't include in ours because it gets pretty weak. But I think we're
You can
comfortable.
live with this. You
Yeah,
said that.
we're comfortable.
You're willing. Yeah. And we appreciate that inching.
And we're not finished yet. I mean, there's still, this is as it came from the House. We're still clearly working on it, so.
Yeah.
A lot of work to go to Pierce.
Yes, we do not support the bill as currently drafted, but that portion of it we do support. But can I, just one last thing?
Wait, can I just
Yeah.
follow up on that, Madam Chair? Because not every town has adopted your code of ethics and conflict policy, right?
No, but this is a law that they adopt once. And I will point out
It's
that
the law. We created that law that they had.
two
to adopt.
thousand nineteen,
Yeah, I mean, that was part of our work on this.
and I don't think we have the data that says there's a lot of complaints. I think there's anecdotal evidence, but also just a quick note that we're passing another law that they could ignore as well. Those that ignore the current law may ignore this law as well. So
But this time, if they don't, if they ignore it, and then a person, a constituent, a townsperson can then say, you ignore this at your peril, I am complaining to the ethics commission, and there's recourse. I mean, they can ignore it, but now they're gonna have to do something about it, because the ethics commission is gonna do something about it.
don't actually think that's accurate.
Oh, sorry,
I don't believe the Ethics Commission can do anything about it in the bill as currently drafted
well.
or in the proposals that I've put out there. I do think the citizens have a right to civil action that could sue the town and get some injunctive relief, but that's gonna require access to a lawyer, it's gonna require paying a lawyer, it's gonna require
Yeah.
the same problems with enforcing our open meeting law and our public records act, right?
Enforcing
Senator
anything.
DeHoste.
Well, this is one of my primary concerns with the bill is that there is no enforcement, and I think there should be. I don't actually think that we should pass laws that say, here's the law, do it if you feel like it. And it was my criticism of the last ethics bill we passed, that there was no enforcement. It was sort of like, here's a list of ethical standards you should follow, like if you don't, whatever. And so I wonder if you could propose some enforcement mechanisms.
I have the ultimate enforcement mechanism, just recall. So I think that allowing towns like you had for about a half dozen to a dozen towns across Vermont, their charters, to have recall based on petition, that would be a great thing. And also with that, the code of ethics and the complaint process and all these things, you actually have a way to put sunshine on the unethical behavior that you might not have had previously. So it would be a really great partner.
Okay,
One
one last thing, go
last real
ahead.
quick,
Yep.
I heard,
Thank you for your patience, Tim.
the executive director just mentioned a change to the recommendation of VLCT to have a seat on the ethics commission.
Oh, right, yes, what are your thoughts?
I would suggest that we mirror the language in almost every other law in Vermont where you're appointing a municipal official to a board that says could be appointed by the governor or the legislature at the recommendation of VLCT. So VLCT gives the governor recommendations or gives you folks recommendations. That's how it happens with things like E911 board, E911 board, the opioid advisory settlement committee, all those things. So it's just an opportunity to give a check and a balance. I disagree with the testimony that we're not a neutral partner, and we certainly have some expertise here, but I have no problem with changing that to include multiple and to give us a recommendation instead of.
So it'd be, you would recommend to the governor or the speaker or whatever, and then they would choose from your list of recommended people?
Yeah.
Okay. All right, we will mull that as well.
I'm doing the house, so I'd love to hear Sue, but I can't stay. But
I don't think Sue will take it personally.
No, I won't.
Thanks, Ted.
Thank you.
All right, Sue, come on up. Sorry, we're behind as usual, but, the reason we invited you, I know you did submit earlier written testimony, but we've heard and had a discussion, from multiple witnesses, about including school boards and in this policy. And so wanted you to be able to respond to that and just give overall testimony on the bill.
Sure, thank you very much.
You're welcome.
I'm Sue Siglowski, Executive Director for the Vermont School Boards Association. And if it's okay with the committee, first, I would like to be able to provide you with some context with a brief overview of the ethics resources that are currently utilized by school boards. We provide new school board members with free training on their roles and responsibilities, and that includes their ethical responsibilities. We also provide free monthly webinars for all of our members. That would be, experienced school board members and new school board members that cover timely topics, and they will include the ethical responsibilities, woven into those webinars. As part of those trainings, school board members learn about what we call the essential work of Vermont school boards, and that's really the framework for school board service, and it has 6 areas. And the reason I'm telling you about these 6 areas is because one of them is effective and ethical operation. That's how important we think this is, that we make it a separate area that we really focus on. So the 6 areas are: first, establish a vision and engage the community. Second is establish policy. Third is budget and financial oversight. And then 4th is effective and ethical operations. And
You sent this to us, Sue, and your testimony.
I haven't sent it to you yet, but I will.
Okay.
5th is board superintendent partnership, which we see as critical. And then 6th is monitoring progress and performance. We provide these resources for school board members in each of the 6 areas. So we break down resources for them in each of these 6 areas. So we have a model policy, delineation of roles and responsibilities of the school board and the superintendent, self-assessment tools, and additional resources. So now I'm going to talk specifically about that area, effective and ethical operations. For that area, we provide a model conflict of interest policy, which I can send to you, and all school boards are required by 16 VSA section 563 subsection 20 to have this policy. So every single school board has this conflict of interest policy. A model code of ethics, delineation of ethics, roles, and responsibilities of the school board and the superintendent, a self-assessment tool, And then our additional resources in this area are a webinar addressing board member conduct. We also have sample procedures for addressing board member conduct and recommended operating protocol. So in addition to the training, we send this book, which is the essential work of Vermont school boards, to each new school board member in the state free of charge. And I'm going to leave a copy of this book, and I can give you 2 copies right now if anyone wants to look at it. In case it's helpful for the committee to see the contents. So specifically, I would point you to the effective and ethical operations section on page 55, the model code of ethics on page 56, the sample board operating protocols on pages 79 through 80, and the section on addressing board member misconduct on pages 92 through 93. The section on addressing board member misconduct states it's the duty of all school board members to adhere to the highest ethical standards, and that the clearer a board is about expectations for board member conduct and a process for addressing that unethical conduct before they run into a situation, the better it's going to be equipped to address issues when they occur. So within that process, there are expectations provided to boards, and those will be in my written testimony that I sent you. I won't go through those all right now, but they're all ethically related. Once a board has discussed and agreed to operate in accordance with those responsibilities, it's really critical that board member conduct that violates those expectations is addressed in a consistent manner. So one way to do that is to adopt a code of ethics at each organizational meeting, which school boards around the state do, and also have a process for addressing board member misconduct. So we provide them with a detailed, a sample process that is quite detailed about what you would do in the event of misconduct.
Senator Clarkson?
So what do you do about enforcement?
We are a member association, so we don't have regulatory authority to enforce anything.
So that's also the problem with the LCT.
Mhm.
They're a member-based organization. And that is, I think, the plus of the Ethics Commission is it is not. And so that is, enforcement could be its great strength.
Well,
Just.
I'm gonna just let Sue finish and then.
Yeah, no, I'm just,
We can get.
but we're on enforcement in our brain, and so I'm just thinking.
Yeah.
You talked about these codes and everybody adopting them, it's great, but then again, who enforces them?
Right, well, I can talk to you about the process that we provide to school boards to utilize. And that is that the process says that it will be considered misconduct for a member of the board to fail to adhere to the expectations agreed to by the board or to engage in conduct that is otherwise injurious to the district. The board chair, or if the situation involves the board chair, another board member shall document and give written notice of the alleged misconduct to the board member. Such written notice may be subject to a public records request and should be limited to a description of the alleged conduct and the specific expectation that was violated by the conduct. And then after 3 documented instances of alleged misconduct or 1 instance of serious misconduct that directly harms the district, the board chair meets to review the conduct of the board member. So they'll meet with the board member. The person who is the subject of the misconduct allegation will be given a chance to view the documentation of the alleged misconduct and to meet with the board chair to respond to the allegations. Discussion of a board member's performance is a permissible subject for discussion in executive session under Vermont's open meeting law. However, any action to censure or issue a formal request for resignation must occur in open session. After that meeting, with the subject of the alleged misconduct, the board chair may recommend 1 or more of the following actions to the full board for its action. 1, board level discussion of the misconduct, including a possible vote of censure against the person in question. 2, communication of the misconduct to the community represented by the board member. Or 3, a formal request for that person's resignation from the board. And then we just provide them with the warning that before taking any of the above actions, the board should consult with its attorney to ensure that they're proceeding in a legal manner. So the above resources that I just spoke about provide school boards with tools to utilize in the event of board member conflict of interest and other possible misconduct. If the committee is considering adding school boards to H 875, I do feel we're coming in sort of quite late in the process and we haven't been involved in any of the previous discussions that the LCT has been involved in. We strongly recommend that you take testimony from the Agency of Education on any interconnectedness or overlap with the new governance standards for school boards, which are part of the district quality standards under Act 127 of 2022. And we also recommend you take testimony from the Vermont Superintendents Association, the Vermont Principals Association, and the Vermont NEA, because it looks like the bill could sweep in administrators and possibly even teachers as officers, as defined in the bill. Additionally, there are concerns about the liaison to the State Ethics Commission outlined in the bill. School boards will be required to designate an employee as their liaison to the commission and designate an officer to receive and investigate complaints. Most likely, this would be an administrator within the school system. And this setup, were it to be particularly the superintendent, would be antithetical to the trust that school boards and superintendents seek to build in order to work together productively for the betterment of their school system. And then I would just lastly say that we are very concerned that adding school boards to the bill will result in additional unfunded costs for school districts at a time when we have an unprecedented number of school budgets that are experiencing multiple defeats.
Thank you, Sue. And you'll submit that
Yes.
testimony, okay, because it's different than what you previously submitted, so.
Yeah.
So this is probably a more appropriate question for one of the people on House Government Operations, but did you testify there? And
No,
they didn't invite you to testify?
No.
And so there wasn't a conversation with you about whether to include school boards over in the House?
not at all.
I might ask Representative Shea, who just came in.
about it.
I'll in just a second. Before we lose Sue, are there any other questions for Sue? She did go over what happens when there is a complaint when you were out.
Okay, sorry, I had to deal with it.
But it's in your written testimony.
Yes.
That sort of process
Yeah.
that people go through.
Yes, and it's in that book too as well.
And it's in this book. Okay. Are there any other further questions?
I'd just like to ask, why do you
Yeah.
think it would cost you more money?
I believe that there would be a significant involvement of legal counsel when these issues arise, causing further legal costs for school districts.
Does each school district have their own lawyer? No.
No,
So,
they don't. So that but they do have legal counsel that they work with.
right, I agree, but most of these are individual complaints, so it would be the individual who was having to foot the bill, not the school district. Or am I crazy?
No, that under boards and the school district would represent the school board member and the complaint, just
Okay, so that now I understand, right, okay. Got it.
if it
Better
comes
for
to
the
legal action.
Yes.
Okay.
Well, before you leave the table, Shay, I'm sorry to put you on the spot but you're the only one from your committee in the room. We're discussing.
And I was the reporter
875.
with Bill.
Oh, right.
The ethics bill, I know,
So the conversation, was there a conversation in your committee about including school boards and why did you decide not to?
There was, it wasn't part of the initial conversation, like when we were first working on the bill. It was brought up later on in the process. And I think the reason why we didn't end up including them was because it was a bandwidth issue for the ethics commission and the ethics director. That possibly it might have to be something, the decision wasn't made to exclude school boards, that they weren't eventually possibly part of this. It's just at this point in time, we were only working on municipalities, and that this was something that could happen in the future. But given, the financial limits on what was available, to pay for the work and the workload that would be put on the ethics commission and the
Okay.
ethics director. It was, they weren't purposely excluded. It
Okay.
was just more thought of as like a phasing kind of situation where it's a possibility that that could be added at any point in the future, but not meant to exclude them for a specific reason,
Okay,
if that makes sense.
that does make sense. All right, thank you, Sue. We'll also mull this, and have you back if we decide to do anything that would involve school boards and also your suggested witnesses.
Thank you.
Yeah, thank you for coming along, here, I'm gonna give you this one back.
Oh, yeah.
I still have my copy of this from many, many years ago. Okay,
You as a teacher are covered by socio.
so committee, I think for each at 875, we're gonna end testimony for today on it. We're gonna have a new draft next time. I will talk with Tim, and also try to get some work on really trying to understand the difference between the whistleblower stuff. And this might also involve Damien. I'm just gonna Tim now, trying to understand the difference between the municipal proposal and what exists in the state. But you and I can talk about it. All right, thank you, Christina, for all of your work on this.
Yeah, really.
And
Your
TJ,
recognition,
thank you.
TJ.
We'll be in touch about next steps.
So appreciated.
Thank you.
Bye,
Take
TJ. Have
care.
a great weekend.
We're gonna actually,
Can Matt get some water, Madam Chair?
yes, actually get some water. We're gonna go to Rep Evans, Waters Evans. And we'll do the vote afterwards.
Hey.
So, since you're here, if
I'm
you'd like
here.
to come up and join
Sure.
us, this
Too
is
bad if I go get water.
I don't mind at all.
Okay.
I'll say my name really slowly.
We doing the vote today or?
We're gonna do that after this, since we have, and then we'll. And.
Yes, so.
This is Town of Ferry.
Oh, boy.
Hi,
Hi.
I'm Representative Shay Waters Evans from the House Government Operations Committee.
Welcome.
I was the reporter of this bill. Will not talk for an hour like I did the last time I was in here. This is gonna be much shorter than the ethics bill. So we had the two representatives from the town of Berry came in and talked to us. They had a charter change request that was approved last year at town meeting because they hold their town meetings in May. So it's their timing wasn't adequate after they voted on the charter change to take it up. At the end of last session. So the bill does two things. First, it changes the town charter to allow the Board of Civil Authority to appoint a vice chair as well as the chair. Yes, there were some issues that the chair was available. There was no vice chair for the meeting. So this enables them to have somebody to run the meeting if the chair was that was the first reason for the change. And the second, it moves the appointment date of those two positions. And it clarifies when they should hold their first meeting. So the timing of things, so their town meeting is in May. They vote for these positions in November. And there was just a lag between them that didn't quite make sense. So the bill changes the date for when they need to be appointed to February 1st by that date.
Okay.
So that they're in place and ready for tax season, town meeting, etc.
Okay.
So they have all their people in the right place.
Senator Bielski, question?
I do, but I think it's actually probably for the officials of the town of
Town,
Berry,
okay.
not Representative Waters Evans.
Okay.
I might know the answer, I don't know, we asked them some questions, but it seemed pretty straightforward. When they voted on it last year, the vote was 1,290 people voted. There are 6,299 voters, registered voters in the town of Berry.
And only 1,200 voters.
Yeah, well, almost 1,300. And the final count on this question was 1,097 yes votes. And 122 no votes.
What was that? Was your vote?
122 no votes. Yes. 120,
It's
yes.
such a divisive issue.
I think sometimes there are individuals that contrarily just wish to vote no on everything.
Where it could have been 122 people who really felt passionately that they did not want a vice chair on their civil authority. We'll never know.
Or it could be that.
I think we should. All right.
And then-
Okay, we will have the, there, thank you, Representative Waters Evans, I appreciate it. We're gonna move to Tim
Great.
now, and then, for just a very quick walkthrough of this very short bill, we'll have some varied folks in. And then we will,
Oh, no, this is town, never mind.
yeah.
Versus the city.
Yeah, yeah,
Talk about
Good
it.
afternoon.
Yeah,
Chair Hardy,
well, town is a different thing.
all right,
committee members.
go ahead.
Thank you for having me, but for the recommending is Tim Devlin, Legislative Council. For you committee members, you have H 862, an act relating to approval of amendments to the charter of the town of Barry, passed by the House. It is a very brief bill with two rote sections and one of substance in between. Section 1 is standard language, enabling and also specifying the date of the vote. So it reads, Charter Amendment Approval. General Assembly approves the amendments to the Charter of the Town of Barry as set forth in this act. The voters approve the proposals of amendment on May 9th, 2023. Moving on to Section 2, which will amend Title 24 Appendices, Chapter 101, which holds the Charter of the Town of Barry, specifically going to Section 6, titled Board of Civil Authority. And you'll see there on line 15, the first sentence that's amended at the first meeting, scratching out following each annual town election to be replaced with on or after February 1st of each year. Board shall elect a chair and new language a vice chair. And then later on, in the event of the absence of the chair and the vice chair, or clerk from the meeting of the board, first order of business, that there should be electing a chair, clerk from the board to serve the balance of the meeting. And that is it. Section 3, effective date, this act shall take effect upon passage.
It's very exciting, bill. Okay, so we'll have the varied folks in. Are there any questions for Tim? Okay.
Oh,
Yes. Yes, Senator Clarkson.
how late is your deadline for charter amendment?
I don't know if there's a deadline.
I don't think there is, because I think Esme was in touch with you about your part.
Oh, right, sorry. So general, the House can introduce a charter at a charter change at any time.
Okay, good. So
All right.
that's why we have charter changes right to the end.
Thanks.
All right, thank you, Tim. We're gonna be back to you soon.
Okay.
We're gonna first vote on the St. Albans Cemetery Association charter that we heard about yesterday. So, but first, Senator Watson, if you wanna help connect Olivia to the folks in Tarrytown, that would be great. And now we are going to do 884 is the cemetery bill that we did yesterday.
Here, we're not selling dead bodies.
We're not
No.
selling dead bodies, we're just allowing them to work under the laws that most other cemeteries work under.
Yeah.
And is there a motion?
I move that we pass out favorably H 884.
Right, any further discussion? All right, Mr. Clerk, could you call the roll?
Senator Wolski.
Yes.
Senator Dwight. Senator Norris, yes. Senator Watson.
Yes.
Senator Clarkson.
Yes, indeed.
Chair Hardy.
Yes.
Senator White.
We don't have
Okay,
a bell to ding.
this one, I assume Senator Norris, you're okay with being the reporter on this?
Yeah.
Okay, awesome. Thank you, everyone. We're gonna not do the Brandon one at this point, because we've, Rep Nugent had to leave, so we'll just schedule that next week. There's no rush on it, but we are now going to turn to page 870, which is the miscellaneous OPR bill.
That's why Heather is here.
Yes. So hi.
Hi, Heather.
And then we have a new, not a full draft, it's instances of amendment on that.
Oh,
So
We're gonna do it. The funding structure stuff?
yeah, we're gonna do a report on it.
Yeah.
Yeah.
So
We need less
Tim,
than
if you,
report.
if you
No,
want
I know, I don't want to do a report. I just want to ask them.
well, and what,
I was excited because I thought we were gonna fix it. I'm less excited that we're gonna report on it first. I'd like to just fix it.
well, this is, we'll hear some testimony on it, but Tim, hi, thank you.
Look at.
Hello again. So we have an amendment to, could you just walk us through the amendment?
Yes, if you have to. So this, let's see, amendment, is on behalf of the committee. And let's see, we'll be amending Bill 870 and Act relating to professions, occupations relating, regulated by the Office of Professional Regulation, or the miscellaneous OPR bill. There are three instances of amendment, one of them a little bit more than the other. The first instance of amendment will add a new section to the bill to be 1A. And this has to do with the Office of Professional Regulation funding structure study. It will amend the, and I think I might have introduced a typo there. That's the incorrect reader assistant heading.
Yeah,
That will be updated. Sorry to purge these things last minute. So anyways, section 1A will actually amend 3 VSA 123, that is duties of the office being the Office of Professional Regulation. Here we have an addition to their existing powers to perform criminal background checks on applicants. And the way the statute is laid out is that it's a enumerated series of different regulated professions that they can do that. It's not all of them, but this will add psychologists, since under section Title 26 VSA Chapter 5 to that list. Among others are speech language pathologists, individuals, which is
that, so,
therapists.
I'm sorry,
Oh, go
yeah, this was at their request, and you might recall that last year we passed a psychologist compact, PsyPact, and that requires background checks, and the OPR does not have the authority right now to perform those background checks. So we added here, the social work compact that we just passed most recently also requires background checks. And in that bill, we gave them the authority to do background checks for social workers, but we had failed to do that last year for psychologists. So we had to add it here. And this was a request from the office to make sure that they have this.
Makes sense.
I guess it surprises me that if we've got individuals on the roster being background checked, that the people who then graduate off the roster to be licensed to practice in some other mental health field aren't also.
Well, we can ask Lauren Lane, who should be here momentarily about why they need this. So
I appreciate you responding to my face.
yes. Yeah, go ahead, Tim.
The second instance of amendment is on page 2. And this will add a reader assistance heading and 3 new sections to be sections 2A to C. Read as follows: naturopathic physicians. Section 2A will amend the definition section found in 18 VSA 4999. And we'll read, as used in this part, certain language struck. Skipping down to 2, licensed healthcare professional as used in 18 VSA, chapter 107, means a physician assistant, a naturopathic physician, or an advanced practice registered nurse. The next section will amend 18 VSA 5071, federal birth certificates, whom to make return. And this adds language in subsection A, shall read on or before the 5th business day of each live birth that occurs in the state, the attending physician or designee, the naturopathic physician or designee, or midwife, or if no attending physician or designee for naturopathic physician designee or midwife is present, a parent of the child or legal guardian mother under 18 years of age shall file with the state registrar a report further informed and in the form and manner prescribed by the state registrar, etc.
So this, we'll hear some more testimony from the naturopath, but this was part of their request to allow naturopathic physicians to be able to sign birth certificates.
Okay.
And this has, and Heather will sort of explain, or Dr. Moore will, but and we have also Brendan Atwood from the Department of Health. This language represents an agreement between the naturopathic physicians and their association and the Department of Health, who worked, as you might recall, we asked them to sort of go and see what they could agree to. So this is part of their agreement, and we'll hear more about it in testimony. So hold that thought for that. Okay.
So we're not gonna talk about death certificates,
Well,
because then
that is,
I don't think it's anything for further.
Yeah, that was my question.
That was my question too.
so,
Birth and death are both supposed to be in there.
yeah, so we'll have
That's
to
what
add
we
that,
thought.
and I missed that when I looked at the draft.
Sorry.
So,
Thank you.
no,
Oh,
that's
it's
okay.
okay,
I haven't
that's, Tanya
seen
and I
it,
were
so-
thinking.
We usually
have
some.
Hi.
Go
I
ahead,
have
Bill,
Bill's
why don't you,
Just gonna make a comment.
yeah,
Okay. The next section to be added in this instance of amendment is section 2C, or near the top of page 3. And this is titled, this is session law, naturopathic physicians technical advisory group, subsection A. On and before September 1st, 2024, the Commissioner of Vermont Department of Health or designee shall convene first meeting of the Naturopathic Physicians Technical Advisory Group. Technical Advisory Group shall discuss the potential integration of naturopathic physicians into statewide policies regarding Vermont's patient choice and end of life laws. It's 18 VSA Chapter 113. The do not resuscitate or DNR orders and advanced directives, and the creation of clinician orders for life-sustaining treatment, COLST. The technical group shall also consider the requirements of integrating naturopathic physicians into statewide policies. It's considered the requirements. So, subsection B, Commissioner of Vermont Department of Health or designee shall chair any meeting or meeting described in this section. And then C, following individuals and entities shall be invited to participate in the meeting or meetings described in this section. We have enumerations of all entities to be invited, including the Association of Accredited Naturopathic Medical Colleges, the Office of Professional Regulation, Patient Choices Vermont, Vermont Association of Naturopathic Physicians, Vermont Ethics Network, Vermont Medical Society, and other entities as needed related to naturopathic medical education. That's subsection C. This is a typo that ought to be B. The Commissioner of the Department of Health shall provide recommendations based on the work of the Technical Advisory Group on or before December 1st, 2024, to the House Committee on Healthcare, the Senate Committee on Health and Welfare, the House Committee on Government Operations and Military Affairs, and the Senate Committee on Government Operations, and that was stuff from the next round. And then DEPA should be E. The Technical Advisory Group shall cease to exist on December 31st, 2024. And that brings us to the end of this section.
Okay, I'm sorry, Tim, that both Senator Lyons and I reviewed it and missed that you hadn't included the death certificates part of it, so I apologize to
I
that.
made that to it.
Okay. Okay, carry on.
The third,
Why you have committee?
Exactly.
You know what? We
why we
feel
do
good.
this. There you go.
the third instance of amendment, and we're now at the bottom of page 4. Let's see, we'll add a reader assistance heading and a new section to be section 18A of the bill. This will be Office of Professional Regulation Funding Structure Study. Section 18A, to be titled, Succession Law, Office of Professional Regulation Funding Structure Study. The Office of Professional Regulation, in consultation with the Joint Fiscal Office, shall conduct a study reviewing the funding structure of the Office of Professional Regulations. The Office of Professional Regulation shall report to the House Committee on Government Operations and Military Affairs and Senate counterpart by January 1st, 2025, with assessment of the benefits, challenges of the current funding method for the Office of Professional Regulation, and with any recommendations for alternative models for funding the Office of Professional Regulation.
And we'll hear from Warren Lehman on this, and Laura, just as a heads up, the date, I'm wondering, think about the date, and whether that's the best date. Okay,
Maybe not.
thank you, Tim. And are there any other questions for Tim at this point? Okay,
5,000.
are you sticking around, or do you have to go to the other meeting?
Let's see. Stick around a little bit, sure.
Okay, whenever you have to leave, I will certainly be in touch with you about this and ethics and probably something else.
Okay, sounds good.
Thank you very much, Tim, appreciate it. All right, we're gonna turn to,
I'm good.
okay, yeah, no problem, as long as we have quorum.
Right, oh, for.
Yeah.
That's why she's leaving now.
Yeah, okay, well, we're gonna turn to Dr. Moore and Brendan Atwood. And you just heard our conversation about what was in the draft, and if I don't know, it doesn't matter to me who goes first, but Brendan, you're listed first, so why don't you take it away, and this is just to sort of discuss, oh, you're so good, let me discuss the conversation you had and the agreement and whether the draft reflects that or what else we need to add or take away. So Brendan, go ahead.
Thanks very much. Good afternoon, Madam Chair and committee members. For the record, my name is Brendan Atwood. I am the Policy Director at the Health Department. So, after meeting with all the stakeholders that we've mentioned before in earlier communications and VANP and OPR, we're pleased to say that we are supportive of this language that we've offered here. So, as Tim noted, it would allow naturopaths to sign birth and death certificates. And just to kind of pick up on the conversation that was happening here, the way this works is that Chapter 107 of Title 18, Section 5202 is the death certificates piece. And what they refer to there is a licensed healthcare professional. So the amendment offered modifies that definition to include naturopathic physicians, and that will allow them to sign death certificates. So though it's not kind of explicitly tied to that there, they are covered, I believe, and Lauren can weigh in on this as well, to be able to sign death certificates with those proposed amendments that are included in this draft.
Oh, so section 2A is the death certificates language of the amendment, section 2A of the amendment.
Let me see, I don't have the 2A.
Well, it might be nice.
Yep, correct.
Okay, all right, well, hey.
She's feeling better. Tim did do it.
Tim did do it, and Ginny and I didn't miss it. So, thank you, Brendan.
You're very welcome. So obviously.
Wait just a second, let me finish, go ahead.
Oh, okay.
Yeah, great, thanks. So we're supportive of that piece. We're also supportive of the stakeholder group and the process that's outlined as well. And we appreciate our collaboration with OPR and the VANP on this, and we look forward to coming back to the legislature with our recommendations later this year. So it's very brief remarks on this, but happy to answer any questions that you may have.
Perfect, thank you so much. Senator Clarkson has a question.
So thank you for clarifying about 2A. However, would you support the notion of just adding clarity that birth and death certificates under section 2B would be helpful to just clarify everybody using these statutes that both certificates are able to be signed by all of the below?
You know, this probably is a better question for Lauren, who's the only lawyer on this group that I know. But I just the way that the statute's constructed, I think that this struck us as the most appropriate way to do it. The licensed healthcare professional is the term that's used in the death certificate section of this chapter 107. So amending it as we have proposed here would essentially accomplish the same thing.
It may, but it's always nice to underscore things sometimes.
Sure, and we'd certainly be open to that if others, in particular the lawyers in the room, thought that made sense.
Yeah, I think it's really a drafting thing in Title 18. So thank you, Brendan. We will check with the lawyers in the room on that. We'll when you come up, you can talk to about it, Lauren. And but Dr. Atwood, or I'm sorry, Dr. Moore. Do you want to just weigh in from your perspective on all of this?
Absolutely. For the record, Dr. Stephen Moore, naturopathic physician, legislative chair of EMP. Mostly I'll just echo what Brendan Atwood had just reiterated. Lovely stakeholder meeting. I felt it was very productive. I look forward to the collegiality and to be able to lay this out so all parties can weigh in and feel comfortable with steps moving forward. So my remarks also will be very brief. Senator Clarkson, thank you for your diligence in highlighting and wanting to make sure the wording is very clear. So I appreciate that. But yeah, remarks are brief on my end, fully supportive of the language at this point and the path moving forward regarding continued meetings with various stakeholders towards the end of COLST DNR and inclusion in Act 39.
That's great. Thank you, Dr. Moore. And thank you both for working together so quickly at our request to come to an agreement and a process moving forward. That is so helpful. I really appreciate it. Brendan, especially the Department of Health, I know you have a lot on your plate right now. So the fact that you were able to pause and do this is really, really helpful.
Thank you, Madam.
Vygotsky has a question.
I do, and I don't know exactly who the question is best directed to. So my understanding, does OPR currently oversee naturopathic physicians, or is it under the Department of Health like other physicians?
OPR is the.
Okay, then my subsequent question is answered, because when I thought it was all under the Department of Health, I was very curious why OPR was on this list for this task force, but you've answered the question.
There you go. Excellent.
New
Well,
professions tend to be, I think, I mean, there was
yeah.
anything new tends to be under. And
Well,
faster.
thank you both for your time today, and we'll just look forward to the report when we get it later this year. And really appreciate your time, and Heather, your time as well for sort of helping us move forward. Yeah, she's good, Senator Vygotsky.
Yeah, I'm also noticing that is a really quick turnaround on that report. Everybody feels like they can do it that quickly.
Yeah.
Yeah, I'm seeing lots of nodding heads, so all right, I will trust you, I'll take it.
I don't think anybody wanted to give up their whole summer. So we're starting in September. I'm gonna do it really condensed.
Great.
All right.
All right, that sounds good. Thank you both so much. Really appreciate it. Have a good weekend.
Thank you, everybody.
Thank you. Have a good weekend.
Lauren, do you want to join us up here? Because you heard a few of the questions we have for you.
Absolutely. So I think Lauren Lehman, General Counsel, Office of Professional Regulation, for the record. So I'll start with those questions. Kind of structurally, why we're in the room, why Vermont Department of Health is in the room is we do regulate naturopaths, and we set out the scope in our chapter and enforce and oversee that profession. Part of our chapter defers says that a naturopath shall comply with state laws regarding vital statistics and communicable disease reporting. And that's in the Department of Health title. So when it comes to changing that kind of function of who can report and who can file death certificates, birth certificates, etc., that's why Department of Health comes in. They're kind of the public health experts and that field and that space, and so OPR defers to them on those subjects. It doesn't really change the scope of a lot, the scope practice of a naturopath remains the same. The authority to practice those functions and whether they're qualified to do so really remains in the public health space. With regard to kind of the structure of the proposed amendment, the way the vital statistics chapter is set up right now, they separate out birth certificates and death certificates. They start with kind of an overall general policy, and then there's a subchapter very specific, or chapter specific to birth certificates. And people that instead of using the term licensed healthcare professional in that chapter, they list out who can who can sign a birth certificate. And that includes physicians, their designees, right now, physicians, designees, midwives, parents, somebody else who was present at birth. This specifically includes naturopaths. So the amended language deals with the birth certificate folks. And then the death certificate chapter, which is after that, instead of listing out the professions who can file a birth certificate, a death certificate, and certify the medical reason for the death certificate, they just say a licensed healthcare professional can certify the medical reason for the death. Which then takes us back to that definition of licensed healthcare profession and why we specify. So we made bold changes, we underlined it, it's just they use different terminologies and approaches to the birth certificates and death certificates for saying who can sign.
Maybe if, just a reader header that says issuing death certificates or something that might help.
Yeah.
Remind people that that's what it is.
Yeah.
Okay, any questions on this part for Lauren? Okay, cool, you wanna move on to the other things?
Yes, absolutely, and I did wanna add that, we're fully supportive and very grateful for the work of the Vermont Association of Naturopathic Physicians and the Department of Health and the others who joined us for that discussion. It was very helpful, and I look forward to continuing that work this fall. So then I'll go to if the committee is open to it, to the money study, the kind of study that we put is in this amendment as well.
Well, we thought of you this morning on the floor because.
Or keep a note.
Yeah, I mean, because with these compacts, we just keep losing fees and we keep losing revenue for the Secretary of State, and so.
Yeah, so
Glad
that's
this section is here.
That's exactly the intent of this section, thank you. What we'd like to look at is currently 3 VSA 124A specifically says the policy of the state is that the cost of regulating the profession shall be borne by that profession. And that one profession shall not subsidize the cost of regulating another profession. What that means is we have to fund all of our programs through the fees we charge licensees. And understandably, licensees can't bear that cost. And so we'll come and ask for fee increases or what have you, but that has to be mitigated. Understanding social worker, a residential contractor can't really bear the cost of a government program. And then we have compacts where the fewer licensees you have in the state, the higher the cost of that borne by the individual Vermont professional. So we're really putting the cost of these on individual professionals when we go into a compact. We offset it in some of them by having a privilege fee, but our privilege fee is $50, whereas our licensing fee might be $105 every 2 years. So we're losing still. So what we proposed here and what we'd like to do is to be able to look at our current structure, and we're significantly underwater at this point in time. We'd like to look at our funding structure, look at other states' funding structures, how they maintain their Office of Professional Regulation, work with the Joint Fiscal Office, and come back with some potential alternative funding models for the Senate, and the legislature this fall. Early winter.
Senator Watson has a question.
Yeah, so you mentioned this very quickly of like a privilege fee or something, and I'm not familiar with what that is. No, yeah, so if you could explain that, and then I have another idea, thing I want to ask about.
Absolutely. So compacts are kind of structured in two ways. One, you either purchase a license in your home state that authorizes you to practice in any of the other states. So when that happens, any of the other states you might go practice in don't get any money.
right.
They still have the obligation to enforce against you, to oversee your practice, etc., but there's no money. So when the nurse licensure compact, you used to have to buy a full license in Vermont if you're from New Hampshire or Massachusetts. Well, you still be from Massachusetts, New York. If you're from New Hampshire or Maine or any of the other states and you wanted to practice in Vermont, you had to pay for that initial license and pay us a fee every 2 years. Now we see none of that. So because they can get the home state license, and get a nurse licensure compact fee, they can practice in Vermont or any other state where the compact's adopted. The other model is called a privilege model, where you get a home state license in that profession, say it's a physical therapist, and then if you want a compact license, you go to this compact commission, which is a third party entity, and say, I want a privilege to practice in New Hampshire and Maine. And so the compact says, great, pay us $50 for the compact administration, and you need to pay us $75 privilege fee for Maine and $75 privilege fee for New Hampshire. And then it remits that state fee to the state. So it's a way of offsetting the cost of the loss of the licensing fees. Each state sets their state fee, and our state has set it at $50.
Okay, well, so that idea of a privilege fee seems to it makes sense to me that would help. And I don't know how one would go about like petitioning these compact organizations to create a privilege fee, but I guess I'll just put that out there as like, that seems like that would be useful.
Right, and it's really an intentional choice in the creation of the model. So the social work compact is a multi-state. The occupational therapy is privileged, and so when the profession and all the states get together, there are some benefits to the licensee for not having to pay a privilege fee for each state, because they, under the nurse licensure compact, they pay one fee to the state for their license. They don't have to pay every single time. Under our state funding model, that shifts the burden onto our state licensees. That doesn't do it for every other state. And so for the whole program, the profession at large, it's actually more beneficial to do the multi-state.
Right.
So that's been the tension, and why looking very intentionally at our funding model and how to move pieces to make it more sustainable is.
Thank you.
Senator Bielanski?
So this is a little bit about the sort of privilege versus multi-state. Are you aware of any considerations, like the way in which these different, because I know you said social work is a multi-state, sort of makes sense given remote telehealth, like say there's 10, 20 states in the compact, if I have to pay $50 in 20 different states, all of a sudden I'm paying $1,000. No, that math is right. All of a sudden I'm paying $1,000 a year to practice, as opposed to like a traveling nurse who might know ahead of time, like, these are the 4 states I'm gonna travel to this year.
Right.
So I appreciate that we're gonna kind of dig into it deeper, because I do think there are fundamental differences in how these different compact professions practice.
Right.
But I'm really glad to see this here, and I'm glad to see that we'll get it back next year, because I know this has been an ongoing and kind of exponentially growing problem.
Right. Yeah, and we support the compacts, and we want to take on providers, and we want to write this report about the doulas, and we want to work in this working group, and we want to do all these things. It's becoming increasingly costly.
Yeah. So, sorry, go ahead.
And you are explicitly going to look at the sort of siloed nature and whether or not perhaps it makes more sense to have a pool of regulation money across profession.
Yeah, and we have that kind of with our advisor professions right now, but the policy is not to do that. And so the other thing we want to look at is kind of the function of our office and the underlying purpose. is the licensing function for the public good or is it for the individual good? So then who should bear the cost of it? Enforcement's kind of for the public good, not so much for the individual good, so who should bear the cost of it? I think kind of that intentional, philosophical and, purpose driven thought process is something we want to engage into.
Perfect. My question is about the date. January 1st is rough. Not for me, but for you. Given that it sort of butts up against holidays and school breaks and all those things. So it's up to you, because you're gonna come, it's your report that you're gonna write for us. So if it works for you, I'm fine, but I just wanted to offer, it could be December 15th or January 15th, so it gives you that bandwidth on either side, but it's totally up to you. I just wanted to flag it.
Thank you, I appreciate that. I think our thinking was we have several things due December 1st. We have that mental health licensure study due December 15th. We wanted to spread out the baby.
I'm sorry.
But I also want, no, not at all. We sorry, Doug, but I also wanted to make sure we got it to you in time for the session, in case we did make changes. So we'd be open to moving it to January 15th if we thought we could still take action next year.
What your budget request, when do you have to go through the same budget process as the rest of the executive branch, as the executive branch agencies do, or are you separate from that?
We're separate because we don't take, OPR does not take any general fund money.
Okay.
So we do not have to.
And when do you submit your budget request to the legislature or whatever?
We've done it only as the project arises at this.
We've done that before.
I'll have to talk with Lauren about how the others SOS branches do it, because I'm sure they must have.
There must have some kind of, that's what I was trying to think of, like, could be coordinated with that in terms of the time. So like I said, it doesn't necessarily matter to me, or I think the committee, it's more about your workload. And if January 1st works for you, that's great, we'll keep it there. But if you want to think about it, we still have time to change it onto that. Senator Clarkson.
So if you could give us a notion of what revenue you're in the, at the moment that you are serving the whole thing, I mean, what are you looking at in terms of the revenue you're foregoing as a result of being a good community participant and enabling all these great things, but that come at a cost?
Yeah, I wanna be careful. I know Nolan wrote fiscal note about this or has
did he?
data about it.
Yes.
I believe our I think we're 7 million total.
Your total budget.
Yeah, and I think our FY 25 is I think it's like 2.3 million short. Don't quote me on that, I need to look at the numbers.
So are you asking at the moment to be made whole in the general fund? Are you asking to be made whole?
We are, now we've asked to do the study to help have the education plan.
There is a little bit of money in the budget that we actually also put on our list.
We did,
But it's very tiny, it's like $67,000.
And that's for the setup, so we have to, for doulas, we're doing a report, so there's a little money there. For peer support, we have to do rules and rulemaking and set that up, so there's a little setup money there. For the compacts, there's setup money, because we have to administratively build that in our system, do outreach, help folks get on board, as well as work with as a delegate to the commission to set up the rules for the compact as well. So it's a lot of it's staff time and some is tech as well. So yeah, we're asking for 67 to offset those four.
And do you know if that made it into the budget? I think it did, but.
I think it did.
I'm pretty sure it did, but we can check for you.
I guess I'm concerned that, over $2 million, you're gonna be short by, what does that mean for your operation? Given that we have elections coming up and we have a lot of expensive stuff coming up this year. Where are you getting that money and how are you functioning if you can?
Functioning bare bones. But we're functioning.
What are you borrowing to cover that gap? What are you doing to cover the gap?
I don't know for sure. I think I'd ask Lauren or Sarah.
This is more of a question how the Lord Hibber.
Okay.
But they have, there's a fund that all of the fees go to, and so I think that basically you're eating up the reserves in that fund, is my impression.
Oh, okay.
And that the other functions of the Secretary of State's office are funded in a different way. So we're just talking about the PR, not the larger Secretary of State's office. But we can have. Well, actually, Lauren Hibbard's not here next.
I can talk to
but
Sarah.
If Sarah, yeah, maybe we have the secretary and ask her about it, but that's, then, before I let you go, Senator Bihowski had one question about the psychologist.
Yeah, around, it was sort of background checks as a whole, I recognize I'm missing some of the language here, in the underlying statute. I understand psychologists were added because of the compact, and then it was just curious to me that we have an existing law that rostered in psychotherapists, we background check, but none of the professions that graduate from the roster are background checked.
No, not unless they're compact. That's a good point. I'm not sure why they initially made that. I think the policy dates back to 98. I'm not sure why that's permitted, but interesting. Maybe it's, I think, because to provide, I mean, they also have, there's no qualifications to be on the roster, so anybody can register, and I think the way they kind of offset, this is my speculation, kind of public risk of that, was to require disclosure statements and.
Yeah, it was really interesting to see that like the mechanism that you, they are, in underlying law. Yeah, they're J.
Did not know that.
Yeah, I thought it was weird.
That is strange. That was the F, like they were put in instead of.
Would you be willing to look into that a
I
little bit and
absolutely
see if
will.
we?
I don't know that we do that.
Okay.
I mean, it's a May, so I don't
The bill
think
is
it's
still
serious.
open if we need to make any changes. Well, great, Lauren, thank you. Any other questions? Great. Thank you.
Could I speak a little bit to massage therapy, or is that something you want to hear about, or?
Sure. Why don't we hear from, can you stick around?
Absolutely.
Why don't we hear from them and then you're welcome to, because I want to make sure we understand what they're testifying. I got a preview, but I want to hear from them directly.
Great, thank you.
Yeah, thank you. So Christine Hoover, are you there? I see your name.
Yes, I am here. Hi.
Awesome.
Can you guys hear me?
Yes,
Great.
so, thanks, Tim. So Christine, if you want to just introduce yourself and who you are, and who you represent, and tell us what you'd like us to know.
Sure. So my name's Christine Hoover. Thank you all for having me. I appreciate it. I manage legislative and regulatory affairs for the American Massage Therapy Association. That's the short story of what I do. And I'm here really representing our AMTA Vermont chapter.
Okay, great.
So you ready to hear my thoughts?
Yeah, go ahead. Let us know.
Okay, so it's kind of a two-part thing on licensure and fees. So we advocate for fair and consistent professional licensing in all 50 states. We promote public education on the efficacy of massage therapy. We foster professional ethics and standards. We represent more than 104,000 members nationwide and more than 340 in Vermont. So the Vermont chapter of the AMTA has strongly advocated for licensure back in 2020. At that time, the profession was not regulated at all. The legislature decided to go in the direction of registration instead of licensure, with rules to be promulgated. The rules, to our knowledge, have not been promulgated yet. So after a couple of years now that we've lived with registration, AMTA Vermont continues to strongly believe that licensure is the appropriate level of regulation, which would join us with 45 other states, the District of Columbia, U.S. Virgin Islands, Guam, and Puerto Rico, which all license massage therapists. Vermont remains behind the curve in the licensure of a profession that is recognized by the Department of Defense and the Department of Veterans Affairs as an effective treatment for chronic pain. Similarly, the Centers for Medicare and Medicaid Services has recommended in their plan benefit guidance therapeutic massage provided by state licensed massage therapists to be a supplemental benefit within Medicare Advantage plans. A state mandated license would require a minimum standard of state specific requirements, would include a clear scope of practice, which we currently don't have, a determined set of educational hours and experience, a study approved curriculum, and passing a psychometrically valid examination. A mandatory license is essential for public protection as well as title protection for massage therapists. We understand this is late in session, and this would be a longer conversation, but just wanted to get that out there while I had your ear before I move on to discussing what we're kind of talking about today with fees. So the current biennial renewal for massage therapy registration recently increased to $275, which took a lot of our profession by surprise. Our initial fee in 2020 was $90. Massage therapists are now expected to pay the same fee as other professions that are licensed, and we are not licensed by OPR. In addition, we are paying significantly higher fees than the renewal for many other licensed professions, including social workers, occupational therapists, and physical therapists pay $180. Cosmetologists, $155, radiologists, therapists, and technicians, $175, and unarmed private investigators have a registration of $95. So this biennial renewal fee of $275 is not commensurate with the level of regulation and are overly burdensome for massage therapists. OPR in their April 2024 report to the legislature contends that the fees are necessary to offset the cost of administration and of unusually high enforcement activity for this profession. However, currently publicly available information shows that only 4 individuals have had their registration removed out of the 1,200 individuals that are currently registered. In addition, records show that there are currently around 400 massage therapists who have allowed their registration to expire. Many, to our knowledge, due to the high fees and the lack of any significant regulation and really any return on investment. So they can't use this registration to go to another state and say, well, I'm registered in Vermont, I should be able to get a license in Maryland or in New York. That's not possible. So high enforcement activity has not been reported by OPR to date. However, in the event that there is in fact a high enforcement rate, that just sort of strengthens our assertion that the profession needs to be properly regulated with licensure as opposed to registration. So thank you very much for indulging me being a little long-winded. I look forward to it.
Christine, you're not long-winded at all. Thank you. That was very clear. And do you have that in writing that you could submit for our website?
Yes, I
already. Perfect. Sorry.
I think I sent it, but we can make sure you have it. Yeah.
Yes, it is. Okay. Great. Senator Clarkson had a question, and then Senator Bielski.
So having been here in 2020 when we did this, as I recall, you had a key piece in this legislation before I worked on it. We did a sunrise review on it. And as I what was our trigger for the next level of OPR oversight? Moving to what's the in-between between registration?
Do you want to just come back up to the table since it seems like we're gonna have questions for both of you?
Yeah.
Lauren Lehman, General Counsel OPR for the record. There's certification, but that's qualifications based and voluntary.
That's number 1. That's lowest.
That's kind of out there. So there's registration, which is mandatory, but you don't need any qualifications to obtain it. There's certification, which is voluntary, but you need qualifications to obtain it. Dietitian,
right?
Anybody can give you dietary advice, but if you want to qualify, you get a certification. And then there's license, which is both mandatory and qualification. So that's the highest level.
And I guess I cannot remember this, but did we put in a trigger to when we should be licensing versus, I mean, how did we put in a trigger in to kind of evolve it and get them licensed versus registration?
You requested a report, an update to see if the regulatory structure was being adequately protective of the public. We submitted that on April 1st. It's on the website now. So that was kind of the trigger to review to see if we were getting a lot of complaints about unskilled practice and injury.
And I hate to ask it, given I have not read the report, I apologize. It's a cruel month, April,
Absolutely.
No. Yeah. So, Christine referred to 4.
Right.
Were there 4 incidents?
So there were 9 complaints filed. 2 were about unskilled practice. 1 was somebody who had some bruising, but they continued to, upon investigation, continue to see the massage therapist and were fine within a week. The other was a woman who complained, or was an individual who complained about witchcraft. And so I don't know if that one was just closed. The other 7 were about sexual assault with regard to 4 individuals. 2 of those individuals were removed from the field. 2, all 4 were removed from the field, 2 permanently and 2 through summary suspension. And so we're waiting for that final hearing to remove their licenses. And then we talked about rate. So we have not seen a decline in people after renewal. We have 1,200 licensees right now. The rate of 9 complaints and 4 people being removed from the profession is significantly higher than the majority of our professions.
Sorry, I thought Christine said there were 300, members of our organization, but there are 1,200 registered.
Yep.
Not licensees, registered.
Registered.
I said registered.
1,210.
1,210, and, so, I'm just, if I may continue.
Yeah.
I mean, given it's just as our friend here, right? That the concern that brought this to us.
Yes, I was
from Middlebury.
Yeah.
I know, I'm remembering very clearly.
Thank you.
Given that we've had 7 sexual assaults in this time, that's a lot. Are you recommending that we move to licensure, or what are we recommending here to try and reduce that? I mean, how many other professions do you have that you oversee that had 7 sexual assaults?
I can't think of another one. I've not done the research, but in all those board meetings and all those CSPs, I cannot think of another one. We did 3 sunrise reports. 2 focused.
I remember that also, that we did quite a few on this.
2 focused solely on medical injury. No, we received no evidence of that being an issue, so recommended against licensure. It wasn't until Senator Hardy and the women of Edison County kind of brought this issue to the forefront of not being able to remove somebody from the profession and sexual assault, that we recommended registration. We've got that chapter 57 requirement that we've got to balance public protection with the minimum necessary to protect against that harm.
But that's a big harm.
That's a big harm, and this is protecting against it.
Yes, because you can remove them.
Right, and so I think it's a very good, we have struck that balance well. I think this evidence shows we struck that balance well. It is a costly profession to regulate, both because of enforcement, but because we've had huge human trafficking cases as well.
Right.
And the report tells how we haven't really cracked that net regulatorily yet, but it's required significant investigation.
And that report, I did read it, and it is on our website, Senator, and if you.
Yeah, no, I know it's there.
I just got it posted this afternoon, so.
Good. Oh, well, it's okay.
Well, I mean, it's on the.
I apologize, that's,
No,
It's
it's
on the website.
Senator Bielski.
So my question's maybe a little bit complex. You feel like we've struck the balance. What is sort of the increase in protection, or, because I know it's minimum lightest touch possible.
Right.
Moving to licensure, what does that shift and change? How could that protect the public more? What would be the additional burden on the profession
So
or OPR?
I don't think we wouldn't necessarily, I think that's what the balance is about, necessarily see more public protection from those increased burdens on the licensee. It would be an increased barrier to people entering the profession. So I have statistics from New Hampshire that they
license, right?
They require 750 hours of training, so that's expensive. They have an examination, and every 2 years they have to do 12 hours of continuing education, so an ongoing expense. In the last 2 years, they've disciplined 6 massage therapists, 2 for practicing without a license, and 4 for sexual misconduct, but none for medical injuries. So even in those states where you've got the heightened burden for the licensee, and honestly would drive a significant portion of these 1,200 people out of the field and not being able to practice the profession in Vermont, you're not seeing the additional public protection gains out of that.
Right, no, it's not dissimilar.
And it's a much bigger state, population wise.
Right.
Yeah.
So my sort of follow-up to that is, like, I've certainly been in these conversations where we're talking about a registry, particularly whatever profession, say, I don't know, contractors, are really opposed. Is it frequent that we have a profession that has a lower level of burden here asking us to give them a higher burden?
Usually if they're doing that, it is because of other external forces, often having to do with payment and reimbursement, that's not OPR's charge. So that kind of is something that is out there, and I feel for the folks that aren't able to, get the insurance contract or whatever, but OPR is not. They're driven by public protection and that chapter 57 balance rather than how to promote the field and get the field reimbursed. So
It's not uncommon in healthcare that
Okay.
people want a higher level
Yeah.
so that they can get higher reimbursements.
Okay.
It's, yeah, so a lot of professions want that. I mean, we're doing a bill about peer support specialists and upping their sort of licensure, or I can't remember what we did, registration, certification, thank you, in order for them to be reimbursed through Medicaid. And so it's kind of common down the hall.
That is helpful context to have, because every time I have worked on a bill to create some kind of registry or certification, the profession in question has come out in droves to tell us that that would destroy them. So it is very interesting
Yeah.
to hear the other side of this.
I think it's just different, sort of triggers that.
Yeah.
In healthcare, it can mean more money. And in other professions, it can just be more, they see it as more burden.
That is helpful context.
Yeah.
So what does it mean here? I mean, your massage therapists are also reimbursed, aren't they?
they are, I think, Christine and I have more information. I think in all fields, there's also, there's title protection, right? So, right now, the title is, and thanks to you, it's massage therapists, body workers, and touch professionals.
Oh, right.
So if anybody wants to call
The
it.
number of different types of massage therapists that we were introduced to during that time.
Right, so I think Christine, you wanna weigh in here because I know that the profession itself has a lot of strong feelings about that issue as well.
Which one do you want me to speak to, the reimbursement or the different professions within the profession?
About both.
Okay, so the reimbursement issue, so massage therapists actually don't, I mean, some do take part in the medical side of things, not as many as you would think, because the reimbursement rate has actually gone down, and whether or not we're licensed really doesn't seem to make that big of a difference. The only unlicensed states right now are Kansas, Minnesota, and Wyoming. Everyone else is either licensed, or you all in California have certification and registration. So it doesn't really make that big of a difference. And actually the VA has just dropped our reimbursement rates. So the impetus behind it really, it's not really a financially driven reason. It's also, we do provide liability insurance to massage therapists, and it's not like, oh, you have to have a state license. We license everyone, and we base it off of their education, their credentials. The problem we have with an unlicensed or underregulated state is that, it's creating it so anyone can come in and say they're a massage therapist. So I know the argument is, well, it's infringing on someone's right to work and right to practice. We want to make sure that someone that has had the education, in most states the minimum is 500 hours, but we do see a range of 500 to 1,000. I think the average is like around 620 to 650. I used to have that number off the top of my head, but we do see a range. So, but at least a minimum of 500 hours of education. Not every state requires continuing education. It's not, the thing you have to bear in mind with our profession is the majority of our massage therapists want to be regulated. They're very proud of what they do. They, want to be recognized as healthcare, and having their state license is sort of that first step. And AMTA has done a lot of work at the federal level with massage therapy being recognized as an alternative to opioids. We're very heavily involved in the passage of the No Pain Act this last December. So there's a lot of pieces at play. I don't think anyone is really going to financially benefit from that. It also does allow massage therapists to be able to use a license from one state to go to another. This is a pretty portable profession. So, you know, the idea is you want to pick up and move and live in another state or spend a summer somewhere else, you can use that existing license to get another state license. It's really hard. I live in an unlicensed state. I live in Kansas, and I know my friends that are massage therapists try to have a license over the state line of Missouri or in Nebraska, just so they have that, because if they want to leave Kansas, they're like, it's going to be so hard for me to get that initial state license. As far as all the other touch professionals, we have a coalition that we meet with every month of about it's like 10 or 11 different touch professional organizations that very staunchly say they are not massage therapy, and a lot of them are trademarked. We've got Bowenwork and Rolfers and structural integration, so things that maybe involve some touch but more energy work, just different from what you would think of as traditional massage therapy. This coalition we belong to usually requests exemptions. They do not want to be licensed as massage therapists, often because the education is different. The requirements they set within their organizations are different. So it would be really hard to say, okay, you have to have this much from a massage school, this much education, and then you have to pass this entry-level massage examination. So we typically kind of filter that out and allow, because again, we don't want to tell them how to regulate their profession. I know when you're outside of the massage world, it's kind of easy to lump it all in and be like, well, it's all the same. Well, there are some differences, and we've just sort of struck that balance with those professions. And I can send some information on the differences and our coalition if you're interested.
Okay, great. Go ahead, Lauren, do you want to add something?
So I do want to point out the reason that we created such broad scope was because it essentially it's the same reason you chose the registration pathway. It's because the identified harm, sexual assault. And so if you're just regulating massage therapists and you remove their registration as massage therapists, they can hang out a shingle as a rolfer or a structural whatever. I'm sorry, I don't remember the terms. But another form of body work. And so we felt it was essential in our recommendations to create a broad definition of who was required to register, again, so we could pull them from the profession if they were in fact responsible for sexual assault.
Yeah. Well, at this point, I think there's not time to really dive into the licensure conversation again this session. We are, as you heard, Christine, OPR is going to look at the fees issue, and I think massage therapists and body workers are a good example of a profession that's paying more than maybe proportionally more than others. So that will be definitely taken into consideration in that study.
We appreciate that. That's the main issue kind of at hand today, is just the cost is really high.
Yeah, I definitely hear you. But thank you so much for reaching out, and it's always good to just have the conversation and remind people of the issues at hand. So I appreciate it.
Yeah, I thank you so much for giving me some time. I really appreciate it.
You're welcome. Have a good weekend.
You too.
Bye. And Lauren, thank you too. If there's anything else that comes up, or if you want to talk further with the secretary about dates and if she is able to come in, maybe just talk about the broader funding thing. Yeah, that would probably be helpful. But why don't you just check in with her? We'll take this bill, and just so the committee knows, and also, health and welfare is going to have a look at the bill before we pass it out, so that if there's any issues, we would just incorporate it into our amendments. We can save a little time. So that will probably be next Wednesday or whatever. Senator Lyons not coordinate on it, but right now, the changes in that amendment are where we're headed with the bill unless somebody else flags something for us, so.
Well,
Okay,
appreciate it.
all right, thank you, Lauren. Really appreciate it. Have a great weekend.